There you go. So now we know the meeting's being recorded. What we're going to do is post these as YouTube videos, and Mike is extremely happy about that because this topic in particular has generated a lot of questions and a lot of confusion, and we're really happy that Mike was able to carve some time out to work on this presentation. Mike Engleson is the Executive Director of Wisconsin Lakes. They are your statewide advocacy organization trying to maybe coalesce all the different people in the state of Wisconsin who work on lake issues. He's been in that position for a number of years. We talked as people were trickling in. He and I have worked on this convention together pretty closely for at least the last 10 years, and I'm happy to call him my friend. Please give a warm Wisconsin Lakes welcome to Mike Engleson.
Thank you, Eric. Thank you, Eric, and everybody at UW Extension and especially UW Extension Lakes program for doing so much work to get this thing put together in a very short amount of time. This was a pretty massive undertaking, and so far, except for what looked like maybe some registration problems that are coming out of my system, everything's going really well. Been dealing with that this morning, so I'm happy to step aside from that and talk a little bit about what's going on with all of this Pier rights stuff. I will say, as way of background, as executive director for Wisconsin Lakes, I do lobbying for our organization, so I spend a lot of time in the Capitol talking to legislators about legislation and such. And I also have a background as an attorney, not currently licensed, so I can't actually give you legal advice, but I do have some understanding of the law. So this was a particularly interesting, when you take the emotions of property ownership out of it, it's a particularly interesting and more thorny question than it might actually appear at first glance. So I'm guessing that some of you in the audience, if not everybody, and you might want to just, if you use that participant window that Eric was talking about, you can click yes or no. I'd be interested in seeing, for people who are here who have either seen these ads, received postcards, heard ads on the radio about all of these, about the, saying that if you have a pier, you're going to lose it. Yeah, looks like quite a few. It was a advertising campaign that was put on by the Wisconsin Homeowners Alliance, which is actually an offshoot of the Wisconsin Realtors Association, and they've spent a lot of money on this issue, raising some pretty big flags for folks, making them wonder what's going on with their pier. The ad campaign, I think, potentially overstated the issue, though on an individual peer-by-peer basis, it could be problematic for some people. So what I wanted to do, and it's a complicated issue, so it takes a little bit of time to explain it, and I thought it would be worthwhile spending a good 45 minutes just sort of running through the details of exactly what happened and how we got here. So what I really want to get past that hype, and we can get at least some sense of what properties are really going to be impacted by the court decision that underlied what this bill that is being promoted. The bill is an attempt to overturn this court decision, and I'll explain all of that. So what is this all about? So there's a bill out being considered by the legislature right now. It was introduced in the Assembly as AB 551 and is in the Senate as SB 501. And I'll get to the details about the legislation a little bit later. But what the legislation attempted to do was overturn a decision of the Wisconsin Supreme Court that was released early in 2018. The case is called Movrich v. Lobermeier. And I'll get into the details of that, but what it really came down to, it was a question of property law. It was riparian rights. How do riparian rights interact with what are called fee simple rights? And so what are fee simple rights? Many of you may be asking. And so before we get into the details of the case, I think I need to go through a little bit of some basic property law so that you understand what those terms mean, and it'll sort of help illustrate what the stakes are in this case and with this bill. So this slide came courtesy of LinkedIn SlideShare, which is something I found on the internet when Googling fee simple bundle of rights. As far as I could tell, these were available for use, so I don't think I'm infringing on anyone's copyright by doing it. I couldn't find the name of the actual presentation that this one came from, though. So but this is from LinkedIn SlideShare. And so what this slide shows, property ownership, when you buy a piece of real estate, you buy it in what's called fee simple. And fee simple is, we all learn in the first day of property law class in law school, is what's called sort of a bundle of property rights. So it's usually termed as the bundle of sticks, which is what this diagram kind of shows. And there's a whole bunch of rights that make up this idea of fee simple ownership. So there are things like the right to occupy and use the property, the right to build on the property, to rent or lease the property. You can sell the property or you can refuse to sell the property. There's a whole basket of sticks of things that you can do with the property. Now, some of those, through government regulation, they can be modified or limited. But even in that case, you're still owning that stick. So if the government says you're limited on what you can build on your property because of zoning laws, you still own the build on your own property stick. One of the sticks, and this is going to be an important one for this Supreme Court decision, is the right to exclude others from your property. And I think that's probably pretty easy to understand. People know that if someone that you have the ability to say to someone, you don't have the right to come on my property. And in fact, if they do, they've committed an infringement of the law against you. Basically, they're guilty of trespass in most cases. And they don't really have to do anything. Just the presence of themselves on your land is in itself a trespass. So that's the ability to exclude others is a pretty fundamental stick within that bundle of sticks of fee simple. This slide, you probably can't see the wording on all of the sticks, but the point of it is just to show that over time, most people, or many times, people will give away or maybe sell one of the sticks that is in their bundle. So for instance, if you mortgage your house, then you've given away the right to prevent someone from foreclosing on you. If you sign an easement allowing someone, access across your property to get to the water or something like that, there you've given away some of your bundle of sticks. So the fee simple isn't necessarily something that is just one concrete thing. These sticks can be doled out and given away. If the government goes too far in regulating one of the sticks so that it's basically taken the entire stick away from you, that's called a takings. You can think about it literally, that someone has taken that stick out of your bundle of property rights and now owns it. The idea being that each of these sticks has some value. These property rights are what make up the value of your property. So if a stick is taken, then the value of your property arguably goes down. If not in actual monetary value, because there's lots of things that influence that, of course, but conceptually, that would be the case. So let's talk about riparian rights now. Riparian rights are generally conferred to lands that border navigable water, and they typically come with a bunch of different um, a bunch of different they're almost their own little bundle of sticks. So um, riparian rights include the reasonable use of the water for domestic or agricultural or recreational purposes. Riparian rights usually include the use of shoreline and access to waters. It does usually include the right to place piers and other structures. So the rights are conferred to lands that border navigable waters. So let's talk a little bit about what navigable waters are. Basically, anytime you can float something in the water, and that has generally been termed to be navigable by the courts of Wisconsin over time. And management and protection of navigable waters is enshrined in our own state's constitution through a doctrine called the public trust doctrine. I recognize many of the names here, and I'm sure you've heard me and other people talk about the public trust before, but very simply, the public trust says that the waters of the state are owned in trust by the state for the use of everyone. And this is a legal doctrine that goes all the way back to, it finds its roots in ancient Roman law and filtered up through the British system and then made its way over into the United States and found its way into the Wisconsin Constitution. So the public trust doctrine is what allows us to be able to use our lakes recreationally. It's the thing that keeps people from putting fences across rivers to prevent people from flowing down the river. We have the right, if it's a river that flows, we have the right to float our boat down. We might not be able to get out off onto the shore and use other people's property, but the waters are held in trust for us. And so riparian rights are not created by the public trust doctrine. Riparian rights are a completely separate piece of law that has evolved over time. And the public trust doctrine actually imposes limitations on riparian rights in protection of that public interest. So riparian rights are subject to, but not created by, the public trust doctrine.
Mike, we've got a quick question.
Sure.
Can we clarify? Tom asks, isn't a riparian owner prohibited from allowing access to a non-riparian?
So that's probably, that might actually be a little more complicated of a question than you would think. And maybe that I might try to come back to that later. It depends on the situation in some respects, but generally, yes, that is true. A riparian can't sell their riparian rights to someone else or give away their riparian rights to someone else. There are, I believe, instances when, say, an easement can be granted that will, you could allow someone to go across your property and use your own pier or something like that. And if you have a more specific question in mind, if we don't get to it in the presentation, maybe we can get to it offline at some point. So let's get into the lawsuit itself that started this whole thing. The case, as I said, was called Movrich v. Lobermeier. Took place on the facts that led to this problem, took place on Sailor Creek flowage, town of Fifield in Price County. This was a dispute among property owners, and it's been cast often as a family dispute, which it was. Ultimately, it came down to the sister, who was the Movrich, and the brother, who was the Lobermeier. But there were other property owners that were in the early stages of this dispute with Mr. Lobermeier on the flowage. And really, I think it's kind of been made, oh, this is just a family dispute. That's not really important to the facts of the case that it was a family. This could have happened with any set of property owners. So Lobermeier owned a portion of the lakebed of this flowage. He didn't own the whole thing. I believe that originally there was a large piece of property that was owned, both shoreland property and lakebed property, that was owned by the Lobermeier's parents. I may be wrong on this, but I believe that was the case. That it was owned by their parents, and then it got split up. Somehow, David Lobermeier ended up with mostly just lakebed. I'm not sure if he had any, I believe he did have some shoreline, but he owned a good chunk of the lakebed that was in front of the property of some of his siblings, at least his sister, who was Movrich. So she owned that piece of shoreline that was adjacent to the Lobermeier's lakebed. They butted up against each other. For a long time, Movrich was allowed to place a pier into the off of their property by Lobermeier. A dispute occurred. I believe it had something to do with a number of the property owners disrupting some habitat structures that the Lobermeiers had put in. It apparently got nasty, and Lobermeier said, "I don't want you to put a pier on my lakebed anymore," and Movrich sued. Before I get into the decision, at this point, there are 3 levels of courts in the state of Wisconsin. There's district court, appeals court, and then the Supreme Court. And the district court and the appeals court ruled in favor of Movrich and her right to place the pier in this case, based on what some people felt was some very circumspect arguments that deeply impacted the public trust doctrine. So I'm actually going to skip ahead. I should put these in a different order. When it got to the Supreme Court, I was approached by an old friend of Wisconsin Lakes and the Wisconsin Lakes Partnership, Attorney Bill O'Connor, who he lobbied for Wisconsin Lakes for a number of years and was involved in the sort of beginnings of all that we are. And he said, we've got a problem because these cases are saying that the public trust doctrine gives the right to riparians to place a pier, essentially. That the presence of navigable waters in the public trust is what gives the right to place the pier, which was not true and potentially created a whole bunch of problems if it had been decided that way, because then depending on how the Supreme Court would have written their opinion, we could have ended up with an opinion that said that anybody could place structures in our waters. It wouldn't even have to be riparians. The way the lower court decisions were written, that was what we began to be worried about. And so we filed what's called a friend of the court brief, which is basically an uninterested, not one of the 2 parties that are suing, can appeal to the court to say, hey, we've got some information that's related to this case that you might want to know, that you'd like to, that would help you, the court, make a good decision in this instance. And so we were allowed by the Supreme Court to file that friend of the court brief. The Realtors Association did so as well on different issues. And then Attorney O'Connor was actually invited to do oral arguments in front of the Supreme Court, which does not normally happen with a friend of the court situation. But he successfully argued that the public trust doctrine did not have anything to do really with this case. And what it came down to was just a decision that had to be made among competing property rights. So I'm seeing in the chat box that it looks like there are maybe some sort of general riparian navigable waters questions. I think I'll save those to the end because I want to make sure that I get through everything related to the case and the bill. But I will try to get back to those at the end. But if anybody has a quick question on what I've talked about so far, as far as the facts of the case or anything like that, feel free to put that in the chat box and I'll try to punch the answers to those in. But right now, I'll just get into what the Supreme Court finally did decide. And this is ultimately what has caused some people some worry and the Realtors Association to launch this advertising campaign. So the decision had 3 basic points, and the first one is probably the most important. So what they said, and again, riparians normally on a naturally occurring body of water that's navigable have riparian rights. But what the court said in this case, Movrich was not entitled to those riparian rights that are incidental to property ownership along a naturally occurring body of water where the lakebed is held in the state, because the lakebed was not held in trust by the state in this instance. It was owned by someone else. It was owned by Lobermeier. So those, we go back to that fee simple right to refuse someone else to come on your property. So essentially what the court said was that Lobermeier's right to say, you can't place a pier into my lakebed, same way that somebody could say, you can't place a shed onto my lawn, overcomes Movrich's right as a riparian to place a pier to use for navigational and recreational purposes, to get to the water. Tom actually has a good question. He asks, how do you own lakebed? That's a very good point. I think I have a later slide that gets into that a little bit, but I'll talk about that right now. So in most cases, if a body of water is a natural body of water and has been deemed a lake, that's always a tricky question depending on the water body, but most of the time, we know whether something is a natural lake or a river or stream. In those cases, the lakebed is held in trust by the state. It's basically owned by the state of Wisconsin. So a private property owner doesn't generally own lakebed of natural lakes. It's different for rivers and streams. In that case, because rivers and streams meander and their course changes, it's a little bit harder for to say the actual land changes, right? So the state does not own that bed. The riparian owns the bed up to the thread of the stream, generally. When you have a flowage, then you have a different situation. So a dam is put into a river, the water backs up, and you have a flowage. Sometimes it's called an impoundment. Sometimes it's a reservoir. There are different words that are used, and sometimes not always with consistent definitions in different places. But for the purpose of this, I'm just going to use the term flowage because that's what the court used in Movrich v. Lobermeier. So a flowage, if it originally started as a river, that lakebed usually doesn't come directly into state ownership. It still retains its ownership with a private entity. So I believe what happened in the case of Sailor Creek flowage and has happened someplace else is that when that land got flooded, there maybe was one riparian that owned a long stretch of shoreline, and let's say they owned all of the, they had property on both sides, and so they actually ended up owning all of the lakebed of that flowage. That property over time got subdivided and sold to other people. And in the case of Sailor Creek flowage, at some point, the lakebed actually got separated from the shoreline properties on that flowage. I don't think that happens very often. And one of the problems with dealing with this case is that we don't have a lot of data yet to know exactly how many of these sorts of instances there are. The time that it occurs most frequently, where the lakebed is owned by someone else than the riparian, the shoreline property owner, is in the case where a utility has put in the dam and then has sold off the upland property around it. That creates its own problems, which I'll get into when we get into the bill and why the utilities objected to it so much. But so really the only time that someone other than the shoreline owner is going to own the lakebed, other than lakebed that's held in trust, is on a flowage, and something had to have happened in a real estate transaction at some point where that either was apparent or could have been apparent. And that's the problem as well, which we'll get into later. So point one of the decision again was that the placement of the pier by Movrich violates Lobermeier's fee simple interest in the lakebed. It violates the Lobermeier's right to refuse someone else to do things on their property. The court also said that, reiterated what I think was already pretty clear in other case law, that the public trust doctrine doesn't convey any property rights. It can modify the property rights of the person that owns the lakebed because it's allowing the public to use those waters for recreation, but it doesn't go so far as to prevent the lakebed owner from stopping someone from putting structures into their lakebed, basically. The court also held that the public trust doctrine does at least allow the Movriches to access the flowage from their property. So they could put a canoe in off the shore if they wanted to. They just can't place structures or put other deposits or do work on the lakebed. They can do that as long as they're using the flowage for public trust purposes. So that's really the same as if there's a public boat landing, anybody can use that landing to put their boat into the lake and go out and use the lake. If you own the property that abuts that water, then you're able to do that as well off your own property, is the idea there. So this is important because there's a question, the way that this case gets interpreted, as to whether or not it completely takes all of the riparian rights away from the shoreline property owner, or just some of them, to the question of whether or not that means that you can put a pier out or not. That may not really matter that much, because the case clearly says that if someone else owns the lakebed, they do have the right to refuse your ability to put out a pier. So to summarize where we are at this point, we've got the Lobermeiers not letting the Movriches placing a pier. There's the lawsuit and the eventual Supreme Court decision in favor of the Lobermeiers that says the public trust doesn't confer property rights, that shoreline owners on flowages with privately flowages with privately owned lakebed may not have some or may not have any riparian rights, depending on how you read the case, and that fee simple right to refuse entry to your property trumps riparian rights even when the property is flooded. All right, so I'll take a step back and see if we have any questions on that. The last question that came in was, is it common situation to have someone other than the state to own lakebed? So yeah, I think I covered that. Again, mostly, as far as I know, the most common instance of it is when a utility owns the lakebed and has sold off upland property. And I'll get into that in more detail in a minute. The other instance would be when the flowage has originally been created, there will be the upland property will also usually have lakebed that comes with it, and it's possible that that lakebed has been sold off. Anybody else have questions that they want to type in quick before I move on?
There was a general question earlier. Scott asked, is it correct that a fisherman or canoeist can access and stand on any pier or diving platform if they access it from the water?
So is it correct that a fisherman canoeist access and stand on any pier or diving platform if they access? You know, I actually, I'm going to have to get back to you on that one, Scott. If you want to, if you have a specific reason you're asking the question and want to contact me directly, because I don't remember that. I feel like there was a ripple to that question that I don't want to give the wrong answer or an incomplete answer. I think the answer is yes, but I don't want to say that without making sure that I've double checked on it. Okay. So again, what this decision, what the question of this issue really comes down to is who gets to keep their stick. When you're a buyer of land that abuts the water, you're probably correct to assume that you hold riparian rights. And I think it's probably correct for a realtor to assume that there are riparian rights that come with that, because that's pretty much the way it's always been cast through, a couple, almost 150, 200 years of selling shoreline property in the state and earlier. But it's also true, I think, that when someone buys a piece of property, whether it's flooded property and is lakebed, that they get to do all the things that you normally would get to do when you buy property. And one of those things is say, I don't want you to do this on my property. So the important thing that I want to make sure that everyone understands is that however this decision, whatever side of this question you're on, at least the way it's being cast right now, someone is going to lose property rights. Someone's going to have to give up their stick, or at least a good chunk of that stick. And so I think that's important to keep in mind. So the decision came out, it kind of sat there and got some notice by some property rights lawyers in the state, but we didn't really hear a whole lot about it. I can't actually say, and this is a good thing, I think. I can't say that I heard of anyone who had ended up feeling, other than I guess the Movriches, that had a problem with this, that this case led to any sorts of issues. But the Realtors Association did have some concerns, and so they spearheaded the creation of this legislation. It was AB 551, SB 501. And I'll just go through the actual text of the bill because it's very short, but as you can tell, is a little bit of language can make for a very difficult and somewhat hard to understand issue. So what the bill says is that an owner of land that abuts a navigable waterway, so not just flowages, but any navigable waterway, is presumed to be a riparian owner. That's been pretty much accepted in the law, and is entitled to exercise all rights afforded to a riparian owner. So really that first piece right there is just more or less codifying what has been in common law, in law that was decided by the courts, and putting it in the state statutes. Up to now, there had not been an explicit statement of a presumption of riparian rights. So, but those riparian rights are subject to the requirements of this chapter being chapter 30 of the statutes. So what that clause is doing is basically saying riparian rights are subject to the public trust, chapter 30 being the place in the statutes where public trust issues reside. So it's acknowledging that fact that there are public interest things that supersede those riparian rights. So if you have land abutting a navigable waterway, you're a riparian owner subject to the requirements of the chapter in the public trust doctrine, including the right to place a pier, other structures, or deposits. So they make that explicit, even if the bed of the waterway is owned in whole or in part by another. So what this bill is saying is that if you are the Movriches, and you only own up to the edge of the water, even though your brother owns the lake bed, you're able to place a pier, to place other structures or deposits, all the sorts of things that you would be able to do as a normal riparian on a natural lake, in this lake where you don't own the lake bed, unless those rights are specifically prohibited by the deed. And that's an important phrase that some people have had some issues with on the bill. So some arguments for the bill, the main one being that the court decision, the Supreme Court, took away sacred property rights of riparians. And I put sacred in quotation marks, not as scare quotes, but as a literal quotation from the dissent in the court case. Justice Ann Walsh Bradley, a generally considered conservative jurist, and Shirley Abramson, a generally considered liberal longtime jurist on the Supreme Court, both dissented in the decision because they believed that the property rights of riparians were, they used the word, well, just as Bradley wrote the dissent, she used the word sacred, saying that this idea that shoreline owners have these riparian rights goes back to the very formation of the state of Wisconsin and probably earlier than that. And that almost for that reason alone, riparian rights really should trump the fee simple right of the right to refuse entry when we're talking about flooded property that is actually lake bed. And it was important that it was flooded property that had navigable water over the top of it. And we can talk a little bit about that in a minute. The other arguments that were made at hearings for the bill was that there was the quote that thousands of property owners would be affected on this. That may be the case. I really can't say because I've not seen any hard data as to exactly how many people, how many property owners would potentially be impacted by this. The argument was made that shoreline buyers bought the property not knowing that lakebed ownership was even an issue that they had to think about. And as I said earlier, that's pretty reasonable. I don't think that most people really thought about this. This is a problem that, you know, really it's a legal question that has existed for again, since these court decisions defining riparian ownership and property law have been made. So probably the entire history of the state of Wisconsin, this problem has been sitting out there and it just hadn't cropped up until, you know, in the last few years. So it's not unreasonable that shoreline buyers would have not thought to even think about this as an issue. There was an argument that taking away the right to place a pier without permission would actually reduce the property value of the shoreline property. Again, we haven't seen anybody present any kind of study that would show that would happen. And there are some people that argue that just the right or not having the right to place a pier wouldn't necessarily in all instances deeply impact the property value. I think on if you're just looking at it, if you're selling property where you have the right to place a pier versus selling property that you don't, it does seem like that's a pretty attractive item that might impact it. So I wouldn't be surprised if it didn't have, wouldn't be shown to have some, but there was not any actual data presented when when this bill was had its public hearing. And then there was an argument that if the property value of these riparian properties is reduced, that will reduce property tax collections, and then other properties in the town will end up getting, end up having to be valued more to collect the same amount. And so it will end up costing everybody, not just the riparian property owners. And again, there was no actual data presented. That was just an argument that was made. But those are all sort of the general suite of arguments that were made in favor of this. On the flip side, there were a number of arguments that were made against it. The first is that the bill takes away those fee simple rights of lakebed property owners that Movrich v. Lobermeier preserved. So it gets back to that slide that I said somebody is going to lose their stick, and you end up either deciding one way or the other who you think that should be. And I've been very interested in having conversations with people. There's been a wide range of opinion on this, even just on a sort of a colloquial level. People seem to have a gut reaction to this one way or the other, even within the lake property ownership community. I've had a number of people, that have expressed both sides of this opinion, which is really why Wisconsin Lakes has not taken a formal opinion for or against the bill, because we know that this comes down. We took care of the conservation issue in this with the Supreme Court case and making sure the public trust doctrine was protected. The property rights issue, because it's split in our membership, we decided that it was best to not take a position on it as a bill, though we have consulted with lawmakers and expressed our sort of general opinions about what the issues mean and how they might impact all of you. So other arguments against the bill include that buyers bought not knowing that they might not have full control of their property. That's the flip side of the third bullet point in the arguments for. There's no hard data of this yet, again, but there's the idea that if you take away that right to refuse entry of another, that property value drops, which could potentially impact the property value of someone's riparian lot. So it could be that a riparian, a shoreland owner, also owns lakebed that fronts their neighbor. So, the person on the right owns a bunch of lakebed. The person to the left of that person does not own the lakebed in front of them. If a part of their property rights are taken away, arguably, their property is not worth as much. And then the last two bullets are really problems specifically with the way this bill is written. And so these, I think, are important and might be a reason to consider whether or not this bill could be redone in a way that would better get at what it's trying to do. So the first is that the bill could negate other methods of voluntarily giving up riparian rights if they're not recorded in the deed. So an example of that would be if you had a conservation easement that wasn't recorded in the deed, and the landowner has agreed to, I'm not going to put a pier in because I've got this conservation easement that maybe goes across their property and out into the lakebed that's owned by someone else. When that shoreline property then got sold, the new owner could potentially argue that that conservation easement doesn't hold anymore. And then utilities had a big problem with the bill, and they've actually gotten an amendment added to it that that at least partially has satisfied their issue, in that when utilities own a flowage, so when the utility owns the lakebed behind the dam has been licensed by the Federal Energy Regulatory Commission, sometimes by a county, there can be state licensing involved. Any number of different entities might have different licensing programs that often will state that the shoreline has to be maintained in a natural state or in some level of conservation protection to keep the water quality of the flowage up to snuff. And the utilities were worried that they were losing the ability to control what the upland owner that they had sold those riparian lots, to whom they had sold the riparian lots, they were losing control of the ability to manage the things that were in their licensing agreements. So the bill had an amendment that would that also said if there was an existing licensing agreement, that licensing agreement would also trump any other rights. So down to the brass tacks, basic question: is your shoreline property going to be impacted by this decision if this bill does not pass? There are a bunch of cases where it's not. It's not if you live on a natural lake where the lake bed is owned by the state. It's not if you live on a river or stream where the riparian owns the bed to the thread of the stream. It's not if you live on a flowage, but you know you own the lake bed yourself. You haven't somehow lost your lake bed, and if you own it, you have the right to put that pier out or not, subject to Chapter 30 in the Public Trust Doctrine. And it won't if you live on a flowage and your deed, or possibly, depending on how things turn out, some other document like an easement expressly provides for riparian rights, with some understanding that that the deed would have to provide for riparian rights as part of an agreement with the owner of the lake bed. Your property might be impacted by the decision if you know you own to the water's edge, but someone else owns the lake bed. And that could actually be true even if you have some sort of cancelable agreement with the lake bed owner. So if it's a utility and you have some sort of agreement with the utility where they say you're able to put out a pier and stuff like that, if that isn't permanent and arguably if it's not in the deed, then that utility could, as they really could have all along, cancel that agreement and impact your ability to put out the pier. So is this affecting a lot of people? Probably not as many as the advertisements would lead one to believe, but there are probably some riparian owners out there that could be put in their right to place the pier could come into question if the lakebed owner wanted to challenge them on it. Again, this isn't a problem that has come up very often in the history of these sorts of property rights. So hopefully it would not be something that happens even if this bill doesn't pass. So where do we go from here? The bill is AB 551 was passed by the Assembly with that amendment. The Senate has yet to take it up, and with the coronavirus limitations on the Senate's ability to even meet, there's some question whether the Senate will get to this bill. I would anticipate if they do, it probably will pass. If it does pass, there might be some further lawsuits because there is an argument that there is a taking on the part of the lakebed owners. We're running short on time. I want to make sure I give everyone time to get connected over to the keynote speaker, but we'll probably have about 5 minutes for questions maybe. But I want to leave you with these thoughts. It is a complicated issue and it is going to cost someone. At the hearings, there were lakebed owners, both Mr. Lobermeier testified and some other people testified who had bought lakebed for the express purpose of doing conservation work on it. And their ability to control what was going on in the water was potentially jeopardized by this decision. There were also people who own piers who were legitimately worried about whether or not they're going to run into problems with putting out their pier. And my wonder is if this bill ends up getting scuttled, is there a chance that there'd be some kind of more equitable solution to provide non-utility lakebed owners some relief while still, in most instances, allowing people to express those riparian rights in the way that they would like to. So it's 8:51. I'm going to use some executive authority and say that we can stretch this to 8:55. The keynote starts at 9 o'clock. But if some of you need to jump off or planning to get over to the keynote room and need to take a break, thank you for listening. But I will try to take some of these questions that are popping up on the chat, and I don't know, maybe Rachel, if you've been paying attention to them better than I have, you can.
Yeah, Mike, I can help you out. So Diane asks, are lakebed owners taxed on their property?
Yes, as far as I know, anybody that owns property that is the lakebed is taxed the same. It may not be taxed at be valued at the same rate as upland property, but yes, it is taxed.
Awesome. And then Leonard Dane asks, have you researched how Illinois handles this issue? There are lakes in Illinois where lake bottom can be owned by someone who doesn't even live on the lake. What about plant treatment or a boat anchor?
So boat anchoring, I believe it is allowed under the public trust doctrine as long as it's not a permanent anchor. So if you're just anchoring because you're fishing or something like that, it's allowed. But I know that at least my understanding is that like anchoring hunting structures or something like that permanently on the lake bottom is not generally currently allowed. And I have not looked at how other states handle the issue. That's actually, in some ways, that's a good question and would be interesting to know. In some ways, Wisconsin Wisconsin law kind of is its own thing, and it might be instructive to get some examples of how it happens. But sometimes other states' laws won't jive, their solutions won't easily fit into Wisconsin's.
Okay, and then Ben Meyer asks, is your understanding that the amendment to the bill has mostly satisfied the concerns of utilities with regard to FERC licensing? And are they generally good with it now?
That's a good question. I have not talked to anyone from the utilities since the amendment was written and introduced. From what I knew of what was going on beforehand, I'm doubtful that they would have agreed to the amendment. They did seem to reduce some of their objections once the amendment got passed. So I think they're probably good. But you know, I think like I said, I haven't talked to them, so I don't want to put words in their mouth. Maybe one more we have time for.
Yeah, absolutely. So Lisa asks, has anyone addressed a truly floating pier that is anchored on the land? It does not touch the bed. Has any Wisconsin county started to reduce land value and increase lakebed assessments?
In answer to the second question, I don't know for sure, but I am guessing the answer is no. I would think that most places would be sort of waiting to see what happens with this legislation before it would even come into that. And it's very kind of up in the air as to how any of this is going to affect assessments either for the upland property or for the lakebed. And then the floating pier issue, there's one way of reading the court decision that makes it seem like that would not be allowed. But at the same time, it's hard to understand how exactly why that would be. So I'm going to give you an ambiguous answer because I think the court was ambiguous on it, and it may end up being the subject of future legal discussions, or it may just be something that the property owners end up working out amongst themselves.
Okay. All right. Well, we can let everyone head on over to the other session. I know a couple folks still had some general questions, Scott and Shelley. If you would like, you can reach out to Mike via email, and I'm sure he can connect with you that way.
Yep, I will definitely try to answer any questions that anybody has to the best of my ability. And I'm still researching this and figuring out. Hopefully, we'll get some more data on how many properties are actually impacted by this as we go through the summer.
All right, Mike. Thank you for your time.
Thank you. Thanks, everybody.
I'm going to unmute everyone here. If we can, whoever's left, we can give a round of applause.
Yeah,
Thank you
Mike,
very much.
very informative.
Thanks, Mike. This
Thank
is Bob.
you.
Showed up late.
Thanks, Mike.
Thank you.
Thank you.
Enjoy the rest of the day, everyone.
Thanks, everybody.
Hey, Mike.
Yeah, Bob.
Sorry about that.
Oh, no problem.
Had some difficulty clicking in this morning. I'm not sure what happened, but it sounded like you managed to do pretty well. Had a good turnout, 80 some odd people involved, so that's great. Can I ask you about the 1040 session?
Yeah, sure.
You've got Todd Ames and Katrina Shanklin. Do you want to introduce them, or do you want me to read their bios?
Why don't you just let me introduce them, because they both had I think they had a 10 o'clock call regarding COVID and may end up not making it. They weren't entirely sure
Okay.
at this